Good morning, Mr. Asyraf and Miss Amalia. I'm Damia Syamimi. Before we start, I would like to introduce my partner, Farah, Fadhilah, Hasanah.
Hello everyone, how are you guys doing? So we hope you don't mind for us to take some notes during the consultation. So before we start, would you mind telling us a little bit about yourself?
Hello everyone, I'm Asyraf Haikal, the Director of Aspirations and Neighborhood, and together with me is my other director.
Hi, I am Amalia Aimi, and thank you for attending to us today.
Mr. Asyraf and Miss Amalia, have you been to a firm before?
Sure, we have been to firms for our other cases previously.
Okay, then, at this point, traditionally we will explain a little bit about how these meetings run, and if you have any question, feel free to ask us.
So first and the most important thing is confidentiality. So are you guys familiar with that term?
Yes.
Okay, just for your information, essentially it means anything that you are telling us today will remain in these four walls. So the reason why we tell you this is because we want to encourage you guys in giving us information. Is that clear?
Yes.
However, there are very few cases that it's mandated by law where we'll have to tell someone, but when we see those cases coming up, we will let you know. And the main reason is basically that you are in the control in that process. Do you have any question about that?
Surely no for now. You may proceed, but may I know how long this consultation will take?
Oh, do you have any time restrictions? Because for your information, the consultation usually will take place not more than 15 minutes. And we will try to make this consultation as casual as possible. And we hope you guys are comfortable. And please feel free to share because the more you share, the more we understand. And it will be better for us to help you.
Now, we will briefly discuss the fees. If you want us to represent you, we do have our standard rates to be charged, which are available according to our policy.
Oh, really? Then may I know how much the fee for our consultation is?
So usually, if it is according to our common rate, it will be 500 ringgit per consultation. So is the price okay for you?
It sounds okay, but other firm we went to for our contract cases only cost like 400 ringgit per consultation. Can you guys lower your fees?
Miss Damia, how is it? Can we reduce our consultation fee?
Sure, then we will charge 400 ringgit for our consultation fee.
Okay. Mr. Ashraf, okay?
Yes. Okay.
We agree to proceed if the consultation fee is only 400 ringgit.
Okay, Mr. Ashraf and Miss Amalia, we would like to inform you that we won't be doing any work without your permission. So if you are going to go and do some work on your behalf, we will be letting you guys know that we'll be taking these actions and it will probably cost about this much. And then you have the decision as to whether or to not to go forward.
Okay, sure. Then if you want to contact us in future, you may contact me or Miss Amalia by using the email address and phone number that we have used to contact you before.
Duly noted, Mr. Ashraf. Well, if you don't have any further questions, so what brings us you guys here and how can we help you?
Okay, basically, we are directors for a company named Aspirations and Neighborhood, and our company is a property developer of a project in Malacca. We actually have a financial problem where we cannot pay for the main contractors of the project and the subcontracts. Over the years, we have noticed that the company has accumulated substantial debt. To our knowledge is that if there is a substantial gap, we need to winding up for the company. But we do not want that to happen. So we come here to seek that may we know whether there is an alternative to rescue our company other than winding up.
Yes, we have an alternative that occurs to your company, which is apply for judicial management.
May we know what is judicial management and how do we apply for judicial management?
Oh, so judicial management is actually a court order. So you guys need to go to the court and apply for the order. And then the court will place a qualified insolvency practitioner known as the judicial manager in your company's management. So the purpose is to revitalize companies that have financial problems. In other words, it gives a chance for your company to continue doing business instead of going out of business entirely.
But is there any requirement for judicial management?
Yes, there are two requirements that need to be fulfilled. The first requirement is that the company and its creditor consider that the company is unable to pay its debt. Second, there is a reasonable probability to rehabilitate the company and serve the interests of the creditor instead of winding up of the company. So, based what you guys have stated, we can say that your company has debts and able to pay your debts, right? Are you guys confident that the company can still be rehabilitated and can pay the creditors instead of being wound up?
Yes, we are very sure and believe that our company can still be recovered. We can give you the necessary documents to prove that matters.
Okay, then you can submit those documents to us at our next consultation meeting next week. Once we have received and gone through the documents, we'll contact you for an inquiries as soon as possible. Is that okay for you guys?
Yes.
Yes.
All right. Aside from this matter, is there any other issue that you might want to consult with us?
Yes. Actually, we do have another issue that we want to seek for your consultation. There is an unsecured creditor in our company named Haris. My question is there any possibility for Haris to intervene in the judicial management that you said before?
Oh, you don't have to worry. For your information, only the secured creditors are allowed to intervene in judicial management applications. So since Haris is unsecured creditor, as you said before, so he cannot intervene on the application.
All right then, Mr. Ashraf, I think we should inform them that Haris has lent his assets to the company.
Oh, yeah, that's right. Miss Damia, Harris also wanted to enforce a security interest over the company's asset that he lent to the company. So does this mean that Harris has the right to winding up?
For your information, if you and Ms. Amalia has applied for application of a judicial management, then Haris does not have rights to apply for a winding up. In addition, since Haris is an unsecured creditor, he also has no rights against the specific property of the debtor, which is you guys, and is prohibited from enforcing security interest over the company assets. Then, do you guys have any final questions?
We think no for now.
Okay, just in case if you have any questions, drop us an email or feel free to contact us.
Sure. Then thank you, Miss Damia Syamimi and Miss Farah Fadhilah for today's consultation.
Thank you
You're
and
welcome.
see you next week.
All right. We might excuse ourselves for now. Thank you.
Okay, Miss Damia, let us proceed to discuss Mr. Ashraf and Miss Amalia's issues since we already have the fact, details, and so on. So what do you think, Miss Damia?
I think for the first and foremost, we can refer to Section 404 of the Companies Act 2016 in regards to the judicial management application. This section provides the elements for the application of the judicial management where a company shall be placed under judicial management and for appointment of judicial manager. The first requirement is that the company and its creditor consider that the company is unable to pay its debt. Second, there is a reasonable probability to rehabilitate the company and serve the interests of the creditor instead of winding up the company. Thus, following the case of Negeri Biases Malaysia Sdn Berhad, where the court stated that before applying the judicial management application, the applicant must consider the Section 404 of Companies Act 2016. According to the court's ruling in Riharis, the term satisfied denotes a higher standard of convincing. Section 466 of the Company Acts contains the definition that applies to the company's inability to pay its debt.
Oh, so based on our client situation, we can see that the company has accumulated debts, right? And Mr. Ashraf and Miss Amalia felt that the company was unable to pay such debts. Nonetheless, if they think that the company's business is still viable and can be put for rehabilitation, they can apply for judicial management. This is provided under Section 404 of the Companies Act 2016, which stated that the company, if the company or its creditor may apply to the court for the company to be put under judicial management order. So upon filing of the judicial management application, the moratorium or on legal proceedings against Exploration Sdn Bhd will take effect immediately. Furthermore, their company, Exploration Sdn Bhd, also satisfies Section 466 of the Companies Act 2016 due to the fact that the company is unable to pay the main contractors and subcontractors, and also plus the fact that the company also had been in debt for several years. So I believe that they have fulfilled the requirements to apply for judicial management order under the Companies Act 2016. However, what about Haris, who wanted to intervene in the judicial management? What do you think?
I believe that Section 409 of the Companies Act 2016 provides that the court shall dismiss an application for judicial management order if the making of the order is opposed by a secured creditor. Besides, referring to the Companies Act 2016, Companies Corporate Rescue Mechanism Rules 2018, Order 13 states that the person who intends to appear at the hearing of an application for judicial management order to oppose the application must be any secured creditor in pursuant to Section 409 Clause B of the Companies Act 2016 and shall serve the notice of intention to appear on the applicant or his solicitor. Based on Mr. Asyraf and Ms. Amalia's situation, there's a possibility for the court to allow the application for judicial management order if the making of the order is opposed by Haris, who is an unsecured creditor. By referring to the case of Million West Links Sdn Bhd against Maybank Investment Bank Berhad and others, Haris is not within the category of specific creditors mentioned in Rule 13 of the Companies Corporate Rescue Mechanism Rules 2018. Therefore, it can be seen that Haris cannot oppose the judicial management application made by Mr. Asyraf and Ms. Amalia. Then, what about the issue of winding up?
Oh, so for the issue of winding up, I think we can refer to Section 410 until 411 of the Act. So Section 410 provides the effect to apply for the judicial management order. So during the beginning period of the application of judicial management order until the very end, any resolution for winding up of a company is prohibited. Besides, any security over the company's property, repossession of the company's property, and any proceeding of a lawsuit against the company is also prohibited. Further, if you can refer to Section 411, Clause 1, Clause B, it also provides that if a judicial management order has been applied, therefore any application for winding up a company shall be dismissed. Also, Section 411, Clause 4, Clause 8 stated that no resolution for winding up of the company shall be passed if the judicial management is enforced. And essentially, Section 411 and Clause 4, Clause D also provides that no step shall be taken to enforce security over the company's property during the enforcement of the judicial management. So I think based on our consultation session earlier, I believe that Haris' winding up application shall be dismissed by the court if Asyraf and Ms. Amalia have already made an application for judicial management. Moreover, Haris is also an unsecured creditor. So he has no right against the specific property of the debtor and is also prohibited from enforcing security interests over the company's asset, as according to Section 410 and 411, Clause 4, Clause D. So we can refer to the case of kumpulan Lizi Sdn Bhd versus Pembinaan Azam Jaya Sdn Bhd, where the application of winding up made by Haris shall be set aside if it was made after the application of judicial management by Asyraf and Amalia. We can also support with the case of CIMB Islamic Sdn Bhd and Welcome Communication, where the winding up application and enforcement of security interests made by Haris is prohibited. This is to protect the status quo of explorations in Bhd. I think that's all from me. What do you think, Ms. Damia?
I think we have made it clear about client's problem for now, right?
Yes, yes.
Then I think that's all for today, and thank you so much, Ms. Hasanah.
Yeah, right back at you, Ms. Damia.
Thank you.
Thank you.